Hi, everyone. Harry here to talk about the actual opinion in the DC Circuit denying Trump immunity. I think it figures to be historic. It's certain to be historic if the Supreme Court opts not to take the case. That's a tricky proposition. I talked about that on the last tape. But even so, I think this will cast a large shadow on various cases for various people, but most immediately, of course, the election interference case with Judge Chutkan, which is now looking more likely that it will occur in time before the November election, though that's not certain. As I calculated, it has a fair bit to do with the Supreme Court's actions. If they take the case, decide the case, while there would still be time, it would be in the dead heat of the election season, assuming, as looks completely certain now, that Trump is the nominee. And you could imagine courts being wary or skittish about that for any of several reasons. Okay, but so the per curiam opinion, it actually displays, per curiam, as I mentioned, I think gives it added oomph. Rather than it being by Judge Henderson with others joining the opinion, you have sort of every word belongs to each of the three judges. But you can pretty easily trace different sections to areas of interest that the judges were pursuing in the oral argument on January 9th. You have, for example, a big discussion about jurisdiction and whether the court even has the power to hear the case based on a Supreme Court unanimous opinion, Midland Asphalt, that by its terms seemed to say they don't have power. But the court, I would say sensibly said, that's overreading Midland Asphalt, or that's just one word in Midland Asphalt, but we think you can be a little bit less strict about it. And what really matters is that this is a right, immunity, not to stand trial in the first place. So it only makes sense for it to be decided on an interlocutory basis. That is, he gets an appeal. And while he does, the district court proceedings are kind of frozen. You have a whole discussion where Marbury versus Madison, the oldest, most famous case in Supreme Court history, not the oldest, but darn close, 1803 or 4, and by Chief Justice John Marshall. And there's a lot of discussion, and this obviously, I think, came from Judge Henderson's questions during oral argument and a distinction that she drew between not being able to police the executive, the judiciary can't second guess, for completely discretionary conduct, like who do you nominate to be a judge? But you can, it doesn't say anything, as she was clear to note, for basically adherence to the law, like not breaking the criminal law. And her fingerprints are also very much all over the discussion of the take care clause in the Constitution and why it would be ironic if somehow the take care clause gave the president a pass on any criminal conduct. So anyway, that's just by way of illustrating. They wrote this all in sections. I'm pretty sure I've been involved as a DC Circuit clerk in per curiam opinions, but they nevertheless consolidate it all and say it's everybody. Okay. And now let's just go through it because it really is very sort of emphatic. First, there's a statement of facts that at every turn make clear that what's alleged is really serious conduct, unprecedented in our history, really going to the heart of the principle of the peaceful transfer of power. Now, they use alleged all the time, but of course they would use alleged. And it's also true that that's what you normally do on a motion to dismiss. Still, here they could have hedged a little because Trump fought the facts so much, and they didn't. They went within and really bring home in a lengthy first section on the facts what is so terrible about what happened. They then move to jurisdiction, and in particular, this case, a 9-zip case in the Supreme Court that basically says for a criminal proceeding like this one, And unlike civil cases where there is the ability to put a stay and proceed interlocutorily, that is, take the appeal right away while the district court doesn't do anything, there is this 9-0 Supreme Court case seeming to say that should be what happens here. And you have a long discussion, I'm thinking by Judge Childs, saying, it's distinguishable on the facts, this 9-0 opinion, and it really doesn't require us. Second, we've been sort of loosey-goosey with it on different occasions. And then third, the main distinction I made, the sort of common sense one, this immunity, unlike what was at issue in Midland Asphalt, which had to do with a violation of grand jury procedures. This really is a right that if you have it, it's not to stand trial in the first place. So it only makes sense that you take it up in advance. That's pretty much all we have to say. And indeed, so now Midland Asphalt, which no one had ever heard of until now, can go back to the ranks of obscurity. But it's pretty long and really thoughtful, one foot in front of the other excerpt or section. Again, I think by Judge Childs, probably started writing maybe even before the oral argument, but it goes into everything. All right. And then they come to the heart of the matter, and we have jurisdiction. So it's the claim for executive immunity. As they put it, former President Trump claims absolute immunity from criminal prosecution. Makes it seem like anything and everything, like shooting someone on Fifth Avenue. That's not the argument, because what it says is criminal prosecution for all official acts undertaken as president, a category he contends that includes all of the conduct alleged in the indictment. So notice it's a two-part kind of submission on his part that they reject. One, he's got immunity for all acts within the bounds of possible bounds, sort of stretchy bounds of official action. And two, the conduct here actually is. The United States says, no, he doesn't, and no, it isn't. So there's precedent here in the civil area for a president having immunity for acts that are within the outer perimeter. And right away, and that decision and case law figured very big in that briefing, but right away they take it off the table. They say the question of whether a president enjoys absolute immunity from federal criminal liability is one of first impression. So that's what they're really focused on. And the civil liability area is of limited utility at best. We got to, decide for the first time, they say, that a former president is categorically immune from federal criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility. And they take it as a question of, first principles and first impression, and they just clobber him. It's the heart of the opinion. And, we could go through it at great length. Let me summarize it this way. The real sort of central analysis is a separation of powers analysis, where they say basically what this would mean is executive uber alles. We, members of the judiciary, members of Congress, both of whom, by the way, are subject to prosecution if they commit crimes, would be powerless to do anything to force the executive to comply with the law. And that would just burst to smithereens the very careful structure of separation of powers that the Constitution provides, and is sort of the heart of the Constitution. So they go through other instances. Nixon's the best example in which presidents have been forced to accede in some way to criminal authority. In Nixon, it was to give evidence, and they just say, the precedent is this way, but really a lot of the opinion is just a matter of first principles. Separation of powers would be out the window if, in fact, we accepted what Trump is arguing. And so that's sort of, a very strong doctrinal argument. It's just, this is the sort of scaffolding of the Constitution, and he would just trash it if we agreed. So the separation of powers doctrine, as expounded in Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, etc. There may be some insulated from judicial review, but basically the president has to be amenable to the laws for his conduct and cannot at his discretion just violate them. That's, really the core. Separation of powers just, demands it. Okay. Another point that people have missed so far, though, is after doing that, they then ground it as well in the right of the people to vote and have their vote counted. So it's not simply that the alleged conduct of President Trump violated separation of powers and would basically negate the constitutionally given checks and balance authority to keep the president to heel, at least as the law is concerned. But it's also that the people's rights to vote and have the vote counted would be grievously transgressed. And it's a double strong way to anchor the opinion because it's, in people's rights. And it's a statement that, at least under the alleged conduct, and how alleged is it when we all saw it on TV, under the real conduct, not just the government, but you and me were really screwed by what Trump did because at least what would have been by what he tried to do, because it would have taken away our right to have our vote counted. All right. They then go, though, it's a case of first impression. They talk about the doctrine, but then they go into policy considerations just as a way of girding. They're not saying that those are what dictate the result, but they undergird the separation of policy results. And they also answer some of Trump's main arguments. Like the big one that he makes is, if a president could be amenable to criminal jurisdiction, it would be chilling. The president would always be afraid that she would be, face criminal prosecution for doing it. And they say, look, first, the history doesn't suggest that there's a lot of these cases. There's really not very much reason to believe that, in fact, it would be chilling. And the presidents we know already take into account, see Nixon say, and the pardon that he got, already take into account the prospect of criminal liability. So, it's not as if they're sitting there thinking, oh, I'll commit crimes and it won't be a problem. Because I'll have this power to go scot-free. In fact, they recognize historically, as what seems to be the record, that you can't just be committing crimes with impunity. So the argument that it'll be chilling, they strongly reject. And indeed, they say that under functional considerations, it could benefit the presidency and the take care clause because that, you can't abuse power in a criminal way. Moreover, there's additional safeguards in place to prevent, Trump raised the specter of tit for tat, terrible indictments. That'll come up again in the state prosecution in Fulton County. What if the DA of East Oklahoma decides to indict Biden the day he leaves office? But this is a federal case, and it's brought by the federal government, and you'd have to posit somehow a sort of tit for tat. Well, you could posit it if Trump becomes president. He's as much as said he would not think of any legal limits and just, go after people. But generally, it's certainly not the way it's supposed to work. It's not the way it has worked. And there are some safeguards against it, the grand jury system itself, but at least it's out there. And then there are other doctrines that a president could point to. And then in addition, when they're talking about functional considerations, and here I think we have Judge Henderson back in play. She says, look, there's the take care clause. It's the very heart and soul of the president's responsibilities. It would be, and she pretty much said this exact same thing in oral argument, a striking paradox. If the president, who alone, I'm quoting now, is vested with constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of denying those laws with impunity. So going through the functional considerations, what would happen if this immunity existed or if it didn't, they again soundly reject it and go through different concerns that he raises and reject them all. Then they come to the public view. Public has a strong interest in the foundational principle that the will of the people, as expressed in the electoral college vote, determines who will serve as president. So, again, there is the individual rights aspect of this all. And here's a great sentence. Former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. Strong words, shows they really know what the stakes are here and why they just can't give them a pass. And then here's the sort of best sort of consolidated statement of separation of powers and individual rights. So read this one short paragraph. We cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results, so that's separation of powers structure, nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and to have their votes count. So individual rights involved here. And that really speaks to all the sort of gambits and ham-handed strategies that Trump was trying to adopt to get Congress to just completely ignore and overcome the will of the people. So many of those things would go directly into this same buzzsaw. So it's important that they lay it down. All right. The rest of the opinion in the law goes at what I consider to be a straw man. Trump's argument that the only way you could be subject to criminal liability as if you were impeached and convicted. It's just a crazy ass argument. It fails on text. It fails in logic. It fails in structure. It fails. And I won't, a lot to be absorbing today. I won't belabor the point by going, through what they have to say there, but they give him the benefit of a long treatment anyway. Probably another judge, perhaps Judge Pan, wrote this one, and it's thorough and methodical and really gives it more than it's worth, as they do with the related claim of double jeopardy principles. Not double jeopardy. His claim here, remember, is not that it would be double jeopardy, but that it's like double jeopardy since he was acquitted and tried in the Senate on impeachment clause. And they're like, no, it's not. Among other things, it wasn't even for the same crime. So, then basically some cleanup stuff from the court, and boom, they end saying that, they make clear that it's categorical in a way, but it really ultimately comes down to balancing, because his claim basically would eviscerate checks and balances as well as individual power. So the way they end the final paragraph, we have balanced former President Trump's asserted interest in executive immunity against the vital public interest that encompasses both separation of powers and people's right to vote that favor allowing this prosecution to proceed. Public policy, law, etc., all counts for it. Accordingly, the order of the district court is affirmed. And that's an important sentence in and of itself, because it doesn't do any hedging. It doesn't say affirmed, but here's a little extra, codicil to think about, etc., something that would give Trump another lease on life by going down, having Judge Chutkan apply it, and then appealing again. That was something I, in particular, had been worried about, and so was very relieved not to see. And the thing we have after that is the mandate. Remarkable, noteworthy, 6 days only, as opposed to at least 21, basically forces his hand to go to the Supreme Court and seek a stay by next Monday. I've talked about that in the other tape. I predict that the court will, seriously consider the stay, maybe even think of it, in fact, as a petition for cert. They've done that in the past when time is short, like in Bush v. Gore. And remember, This is a case in which the special counsel already came in urging them to take it before the DC Circuit went running with it. So they might even take that as a petition for cert. But as I've explained, including in tweets, takes 4 votes to take the case, and that would and 5 votes though to grant the stay. So it's theoretically possible. I don't think very likely, but what he really needs is the stay. He needs the 5 votes, not just the 4. But if they take up the case, probably they go they go with a very expedited schedule. But even so, probably they go till the end of June. Probably we're looking at trial more like September rather than otherwise about June. In other words, right in the heart of the campaign. And that will raise a whole different set of issues about, whether there's some implicit constitutional or legal principle saying, you just can't do that. It's just too big a mess when the criminal defendant is simultaneously the person who is making his pitch to the American people to decide whether to, God forbid, elect him again as president. Okay, so there you have more of the content stuff. The big ticket items and what happens next are in the other YouTube, which I recommend checking out if you haven't so far. But this is an opinion for the ages. It'll be really so if the Supreme Court doesn't come in. But either way, it's emphatic, comprehensive, per curiam, really impressive. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.